Your Honor, the first case on the docket for Monday, March 28th, 2022 is appeal number 123856, State of Kansas versus Shelbert Smith, Sedgwick County. Briefs both sides.
Thank you, Mr. Shima. Counsel on the case, please approach counsel table. Once you're both settled, if you would come to the lectern to please state your appearances.
May it please the court, Richard Ney for the appellant, Shelbert Smith, present, ready for argument.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you. Renee, when you're ready, you may begin your argument.
Madam Chief Justice, may it please the court, Richard Ney, again, for Shelbert Smith, the appellant. Madam Chief Justice, if I could request 3 minutes of my time for rebuttal.
3 minutes is granted.
In 1993, Shelbert Smith, at the age of 16, pled no contest without any kind of plea agreement to murder, kidnapping, and robbery. He was sentenced to 2 consecutive life sentences plus 10 years to life for what we would term a virtual life sentence. He appeals this sentence based on Miller versus Alabama, which prohibits life sentences against juveniles without consideration of their youth. Now, the first question I will attempt to address today is why 28 years later, the defendant, after he was sentenced, the defendant should be allowed to appeal. And the answer, I believe, is simple enough. The defendant's time to appeal, even as today, has never started running. There was never a journal entry filed in this case denying Mr. Smith's so-called callback motion, as was termed at the time.
Counsel, how would you characterize what was filed by the judge? What was that?
It was a sentencing notation, or I'm sorry, a motion notation. And it's in the record, and the notation says denying the defendant's callback or modification of sentence. I'm old enough to have done, and we called them callbacks. And the box was checked that said, this order will be followed by a journal entry. The state is ordered to prepare a journal entry.
I understand that, but technically, what is that? Is it just judge's notes? It was written down, it was filed like as journal entries are. And I've seen that the box wasn't checked, but what is it? Nothing?
It is nothing in those circumstances. The box was checked, ordering the DA to file an order, to file a journal entry. So that commanded to do so. Now, if we look at the law, there's 2, I think, legal provisions that are appropriate. One is Rule 134. And that states that if a court rules on a motion or other application, when an affected party who has appeared in the action is not present, and we all agreed, Mr. Smith wasn't present, his counsel wasn't present, and the DA was not present when this was issued. That's a stipulation in the record. The court immediately must serve notice of the ruling. So we've got that problem. Even if we say, Your Honor, that was something, and we say it's nothing, it has to be served, and it was never served. No one contends it was. In fact, the stipulation from the prosecutor, now Judge Kaufman, said he never saw it. And if he'd seen it, of course, he would have done a journal entry.
Is it significant that there's nothing in the record about what the court did or what the court says it did? Are you saying it has to be remanded, or can that be determined on the record?
That can be determined on the record. We know there was this minute sheet, and then that's what's colloquially it's called, a minute sheet of this motion.
But isn't the voice of the court important when making that decision?
Well, I think the law is more important. The judges
I mean, as to whether or not it was served. The voice of the court saying we did or did not serve?
There's an agreement, it was never served. The record stipulates Judge Kaufman didn't get it, defense counsel didn't get it, and my 16-year-old client at the time, who was in prison, didn't get it. So there really is no contention about that. The other provision we would cite the court to is 60-258. Does an entry of judgment is subject to section B, it goes on, no judgment is effective unless and until a journal entry or judgment form is signed by the judge and filed with the clerk. This is not a journal entry. And then it goes on to say, when judgment is entered by judgment form, let's call this a judgment form, the clerk must serve a copy of the judgment form on all attorneys of record within 3 days, excluding Saturdays, Sundays, and holidays. That was never done. That was agreed to below. So Mr. Smith's time did not run. And we're in a real dilemma here. We know he wasn't in court, and there's no way back in those days for a defendant who is getting a call back to know his motion's been ruled on, unless he's served with it or someone tells him. It's not, there was no court date set, it's not a set amount of time, it's within 120 days.
Counsel,
Yes.
do we know from the record when Mr. Smith had actual knowledge or actual notice of the entry of the minute sheet or the motion minute sheet?
We don't. Mr. Smith tried to file an appeal. Again, we've had numerous hearings on this, as the court knows. He tried to file a pro se appeal, which the court denied. That was Smith 1. And then I got involved in the case. We went back again. It was denied again. That was Smith 2. We went back on Ortiz issues. That was Smith 3. So at least at some point there's knowledge, but Mr. Smith is now not 16 anymore and intellectually disabled, basically, as we pointed out. He had ADHD, was functionally illiterate. It's not clear that he ever knew until he tried to appeal and was told, no, you're out of time.
And was that at Smith 1? I mean, effectively was notice given when the record on appeal was prepared in Smith 1?
Well, in Smith 1 was an attempt to appeal out of time based on Ortiz exception.
Right, but a record on appeal was presumably prepared, and counsel would have presumably had access to the entire court file at that point. So wouldn't counsel at least have had some notice at that point that motion had been ruled on?
Well, everyone knew the motion had been ruled on. I don't think there was any question about that. That was in the record. But the question was counsel served?
What does service mean? I mean, counsel then had a copy or had access to a copy, became aware of it. Does that trigger?
Well, you're talking about the original counsel, Your Honor?
No, I'm talking about appellate counsel at that point. Is that the date by which the
Well,
30 days becomes triggered?
I don't think so, because if it's not been filed per Rule 134 and under 6258, then it's not filed. It's never been filed. It's still today is an open issue, in our opinion.
Explain to me what you mean by filed in that context.
There's been no journal entry, ever.
No journal entry, right. But a minute sheet that records it, that gives us now notice, does that change it once everybody knows there has been a ruling by the court?
Absolutely, it keeps the issue open, because the judge said in that minute sheet, if we're going to say the minute sheet is controlling, it also is controlling, say, the district attorney must file a journal entry. This isn't it, the court said. This is not the journal entry.
And was the court even still on the bench at that point?
Judge Clark, no.
Yeah. So what do we do in that situation?
You let Mr. Smith appeal, because there's been no journal entry. I mean, I guess you're posing the question to me, why didn't counsel in Smith 1, and I can't speak for counsel in Smith 1, I can speak for counsel in Smith 2 and 3 and 4, I guess, since that's me. But counsel in Smith 1, why didn't he raise this issue? Well, we can say it the other way. Why didn't the state, when they saw on Smith 1, this journal entry or this lack of journal entry, this minute sheet, why didn't they file a journal entry then denying it? They still haven't.
Is there some point when when all of the Ortiz arguments are either made or they have been waived? Is it only once all three Ortiz exceptions have been raised that
No,
we're done, or?
no, this first Ortiz exception we tried to raise. That was Smith 3. Saying, look, if you look at Mr. Smith's pleadings, he does really raise first and third exceptions. The court said, well, that wasn't my mandate, so I'm not going to hear it. And this court said, yeah, that wasn't the mandate. He shouldn't hear it. So we didn't get that resolved. So as an alternative here, we are raising the first Ortiz exception. And that's another alternative for this court. When Mr. Smith entered his plea, again, 16, illiterate, as we've shown, with ADHD, basically our expert said he had the intellectual abilities basically of a 6-year-old. When he entered his plea, he was told, you have a right to appeal from a jury finding. Well, that's not completely correct. Look at the plea transcript from the court. The court is telling him, here's your rights, and you're giving up those rights. You could appeal from a jury finding, but you're giving up that right if you enter a plea. He's never told about appeal. In the sentencing, the 8-page or 7-page actually sentencing transcript, the word appeal is not mentioned one single time. So he's never told about appeals. Forget about patent, that there's some patent issue had been messed. None of them. He was never told about an appeal. And he certainly wasn't told about an appeal at sentencing and that he could appeal from his sentence. And that's critical here because in those days, again, my historical knowledge provides that if Mr. Smith had appealed after his callback was denied, he could have gotten another callback, even if his appeal was denied. So you've got a 16-year-old kid doing 2 life sentences plus, who had a second shot, even a worthless appeal would have got him a second callback.
Counsel, what effect from Smith 3 mandate finding that Smith wouldn't have appealed anyway? What effect does that have on Ortiz 1 exception?
Well, that was just an assertion by the court. He doesn't believe he would have appealed. He'd been trying to appeal. He was 16 years old. He said he tried to appeal. His grandmother, who he brought forward, testified she kept trying to contact the attorney, Mr. Opperman, and the purpose of trying to contact him, the attorney, was to file that appeal.
So your response is it wasn't a ruling, it was just dicta?
I think it is dicta if we haven't reached the appeal issue, and it's not based on the evidence. Again, there's a great reason this kid would have appealed when he was first sentenced. Not only because he's facing 2 lives plus, but because he would have given him another shot, no matter how remote, at a chance to modify a sentence. I see my time is up, unless there are other questions.
The merits of your constitutional claim.
Yes.
It appears to me that this was a discretionary sentence. At the time the court imposed it, it wasn't a mandatory sentence that was imposed. It wasn't life without parole. The court even said, factors I must by law, I will consider your age. And those seems to fit right into the concerns and what was addressed by the latest U.S. Supreme Court case, the Jones case. That's the crux of your appeal, isn't it? It's an unconstitutional appeal based upon age. The court didn't consider that as a factor, and it's a mandatory life without parole. So
Yes.
just kind of generally address that.
Certainly, Your Honor. And could I trouble Your Honor, you're quoting from the court in what?
I'm sorry, I'll consider your age that.
That's in the
But
sentence.
no, that's from the district court judge that imposed sentence at the time of sentencing. When he sent your client to the KRDC for an evaluation, he said, "I will consider your age in making this determination." That's what he said. It's a quote.
When he's talking about considering the callback.
Yes.
All right, I will check the record on that.
But that's at least,
Yeah, that's fine.
two different places I see where he says that.
I think the problem is, Your Honor, that we have a situation where that Mr. Smith is being sentenced. Again, the sentencing transcript, 7 pages long, which includes the talk about the callback. So there's really not much. His counsel mentions the word age once. When he is sentenced, the judge is not saying he's considering that sentence or his age when he's imposing the double life plus sentence. So there really, our position would be no consideration of my client's age and not only did he have the disabilities of age that's talked about in Miller, he had a lot of other disabilities.
I understand. Okay.
So we believe that an Eighth Amendment issue is raised.
Hey, my notes show that's at record volume 4, page 7.
Thank you, Your Honor.
Any other questions? Thank you, Mr. Nang. Mr. Gillette?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. Your Honors, I'm asking you all to collectively not throw up your hands in the air based on the procedural quagmire that we find ourselves facing today, but to rather collectively put your feet down and apply the appropriate jurisdictional rules to enforce our procedures to make sure that we see an orderly administration of justice in this case. I want to start with the fact that we continue to assert that there is no jurisdiction to consider this appeal. I will address the arguments in order, first starting with the journal entry, then moving on to Ortiz 1. Regarding the journal entry, I think one of the most appropriate questions that was been asked was, at some point, isn't there knowledge? And the answer to that question is absolutely yes. In fact, at the last oral argument in this case, opposing counsel acknowledged that this was something that had been known, that there was not a journal entry reflecting the court's action filed. That's been known since Smith 1. And it was not raised there. It wasn't raised in Smith 2. Opposing counsel tried to raise it in Smith 3, but it was outside of this court's very specific remand order in that case, so it was not before the court. It was not raised before the district court still here today. We have not seen a request for a remand. We have not seen a request for or a filing in the district court seeking to litigate this matter. And to that end, it appears to be strategic to try to avoid an argument regarding latches, which we noted in Smith 3, despite the fact it was beyond the scope of the remand, to try to preserve that issue just in case. But opposing counsel was correct in their briefs to say that latches has to be pleaded at the district court. How do we get a chance to do that if he won't make his claim in an appropriate manner? The answer is we can't. We can't get a fair shot to try to litigate this issue if the defendant won't play by the rules.
Let me interrupt just a second here. So I thought you were going somewhere else with your argument. So I was,
Okay.
That's kind of what prompts this. What's the triggering event or appellate jurisdiction?
We believe that the triggering event for appellate jurisdiction in this case is the district court's filing its minute sheet.
Is it a
denial.
filing or is it the imposition of sentence?
In this case, because of the way that the law was at the time, his sentence was imposed, but he had up to 130 days if a timely motion for callback was filed.
Right, but that statute says, front of me here, if sentence is imposed, comma,
Yeah.
I'm just, so when sentence imposed?
I think that in this case, in trying to be as fair as we possibly can to the defendant, we'd give him 130 days because he filed a
Was
timely
sentence
motion.
imposed? Was it imposed from the bench, I guess is where I'm coming from? Because I thought that was the deal, that, you know, when the court speaks, that's the sentence is imposed.
Yes,
So if that's, and there's no doubt the court imposed a sentence because everybody was there when it happened.
correct.
I'm just wondering if that isn't the trigger event. And so it doesn't really matter whether this minute sheet, that he had notice of the minute sheet, because for jurisdictional purposes, the triggering event is imposition of sentence. And then when you combine the statutes and the case law, you sort of get 130 days to try to modify this, for the court to be able to modify the sentence. And when you're done with that, it seems like you're done.
That's correct. I would agree with everything that your honors just said.
Then
I
why are
think-
you talking about notice and minute sheets and all this other stuff?
To be perfectly candid, I think it's because we are trying to be as deferential as we possibly can to give the defendant, even giving the defendant the maximum time possible, the full 130 days. He cannot, never has tried to take a timely appeal. I think that's the best answer that I had to that question.
But if just, you don't have to be nice to him. He's
No.
got 130 days and nothing happened in that 130. That's all I'm getting at.
And that's a completely fair analysis. And if it's his attempt to appeal from the sentence, if that passed 30 days beyond judgment, then he is woefully out of time. If we consider just this as some sort of an appeal from the denial of his motion to modify, then again, it's secondarily, it's still woefully out of time. Sentence for, just so that we are clear, it was imposed in December of 1993. His motion to modify filed timely on February 14th of 1994. And then the minute sheet denying that was on March 3rd of 1994.
But State versus G was decided in 1994 and directly refutes that position, doesn't it?
Respectfully, Your Honor, no. And that's because this case is absolutely distinguishable from G and the Myers case that G cited. There are two things that were required to lead to the result in G that do not exist here. G, what we saw was an oral pronouncement denying the motion to modify. So in that circumstance, all that would exist is a transcript out in the ether. There's no way that an oral ruling when the parties aren't present is ever going to make its way to the parties. Here we have this minute sheet, and it does mean something. Opposing counsel said today there was some kind of a stipulation that it was not served. That's not accurate. There's only an indication that it was not served. The only stipulation was it wasn't served on now Judge Kaufman. There's been no evidence one way or the other whether or not it was served on defense counsel. Second thing that was required to reach the ruling in G was that the district court took some kind of action outside of the maximum allowed 130 days. And in that case, basically this court crafted an exception to the standard 10-day window in which a defendant can file a notice of appeal because ordinarily, and as we assert in this case, that 130-day deadline should be a hard and fast rule. There's no question. If you haven't heard something, you haven't learned that your sentence was modified within the 120-day callback time, for the love of God, do something on day 130. But
Counsel, I'm
Yeah.
going to interrupt you. Sorry to cut you off, but that's the question. What you're talking about is really the question I want to ask, which is, as you understand the law of appellate jurisdiction, is it permissible for this court to grant itself jurisdiction absent statutory language that at least we're interpreting or construing?
no, as Your Honor well knows, I think the case law is pretty clear that this court's jurisdiction is conferred only by statute.
And so what do we do with, I mean, my reading of G is essentially as you recited it, which is we crafted an exception. Is that your understanding as well?
That's my understanding as well.
And so I guess I get back to maybe what Justice Biles was suggesting, which is why not just argue that G is wrong and we ought to fix it?
I think that would be appropriate, to be perfectly honest. It's something that wasn't briefed. If additional briefing is needed on that point, I'm happy to do that. I mean,
I don't know that we need to, I mean, the Park City case is pretty clear that appellate courts can't create equitable exceptions to a jurisdictional question. So it seems to me if that door was open in G, it's closed in Park City. And we're still down to just sort of a hard or it's not fair or whatever. We're down to a hard and fast. How do we apply these statutes that confer appellate jurisdiction? And once we answer that question, it seems to me, then you're done.
and I think that again, that is an absolutely fair way to consider this case, and the defendant should be done. I don't believe that there is jurisdiction.
Does it matter that the docketing statement in this case reads that the issue is that the court erred in sentencing the defendant, as opposed to the court erred in failing to grant a motion to modify?
I don't know that it necessarily matters because, to be perfectly candid, there's not, strictly speaking, a ruling from the district court for the defendant to even be appealing from here, because he didn't raise this below and he's never asked for a remand to try to assert Ortiz 1. So I don't know if he's trying to assert a sentencing claim straight on, and I will move to that here shortly. Can't raise an illegal sentence claim. It's a constitutional challenge. And as Justice Rosen pointed out, I think that the case law is pretty clear, and the record here is extremely clear that age was considered in imposing this discretionary sentence. So he can't win on the merits. So ultimately, I don't know that it does matter. I'll briefly mention the Ortiz 1 before concluding again of the merits. Ortiz 1, the first Ortiz exception, that exception was actually raised by the defendant in 2013 when he filed his motion. He abandoned it. There is no record here regarding Ortiz 1 for this court to review. To the extent that this court can review the record from Smith 3, as the defendant suggests it can, he must lose. Defendant knew everything he needed to know, as we've briefed, based on paragraph 8 in his acknowledgement of rights. It explained explicitly the 3 requirements that were necessary under patent for his actual knowledge of the right to appeal. And there was significant evidence of additional sources of knowledge. And then we do, Justice Wilson, have the finding from the district court that the defendant would not appeal. Even if he had an attorney, he knew all of his appeal rights. The finding from the district court here is the law of the case. He was not going to appeal. Why? I don't necessarily know, but there is at least a suggestion in this court that we had a defendant who was taking responsibility for the fact that he basically plotted and carried out an execution.
Let me ask, thank you.
Yeah.
A question about the defendant knew, and that's based on the fact that he had a copy of the plea agreement. Is that right?
Acknowledgement of rights and his
Rights.
and his signature thereon, and his agreeing on the record at the time of plea that he had gone over that with his attorney, understood everything, and was
And the evidence of that is his affirmative responses when the district court asked.
yes.
Do we take into account at all the evidence introduced about his being almost illiterate, and that his understanding was that of a 6-year-old?
No, to be perfectly candid, for whatever value the defense's purported expert may have in this case, I don't mean in any way to impugn his expertise, but I would ask this court to consider the scope of his review. And in this case, he undertook no steps, no efforts to even review the transcript in this case. But what he was able to concede ultimately, he didn't consider anything from this case.
Wait, who didn't consider?
The expert, he didn't consider anything from this case. But what he ultimately did concede is that in a setting, one-on-one, going over something like the defendant would have with this acknowledgement of rights, like he admitted he did, then it would be fully capable of understanding.
If it was repeatedly, wasn't the word that if you repeatedly went over it with him?
I don't think so. I think it was just a one-on-one going at the defendant's pace, going slowly, being clear, he would understand.
Like a 6-year-old would understand.
No, that he would understand fully, that he would fully understand what he was doing in this case. I believe the expert conceded that.
And was that tied to the acknowledgement of rights, or that was just generally instructions or advising?
That
6-year-old?
That was it. He wasn't a 6-year-old. I have to be clear. He was saying that in any circumstance, if you sit down and go over something like we would have done here, go over it slowly, one-on-one, give the defendant an opportunity to ask questions and have them answered, he would be fully capable of understanding that. And that's what would have happened with this acknowledgement of rights, as the defendant acknowledged.
What about the evidence supporting the other finding that he would not have appealed?
Yes.
What is that?
I think that this basically was tied to his claim under the third Ortiz exception, that even knowing everything that he would have wanted to appeal. Here we have an indications from the record that this defendant waited nearly 20 years to do something. In every attempt that he described to try to contact his attorney, he never mentioned asking for an appeal. When he had his mother and his grandmother try to contact this attorney, they never asked about an appeal.
What was the evidence in the record about why then the mother kept calling her grandmother?
I don't know that he had asked her.
What other reason would there be?
I don't know, but it's the defendant's burden to prove what the purpose was. It was his burden to prove that an exception would apply that would allow him to appeal out of time, and there was no evidence. Maybe it was because he wanted to try to file a 60-1507 motion. Maybe he wanted to sue someone in the Department of Corrections. I don't know. There are many reasons why he could have been asking.
And to Justice Wall's question, what evidence is there to support the district court's finding of fact that he wouldn't have wanted to appeal?
And I repeat the things that I pointed out, that I noted to Justice Wall, the time delay, the fact.
But there was no, what was the time delay at that point?
At that point, so at that point, he was not asking, there was no evidence that he was asking his mother or his aunt, or that he himself was asking for an appeal in all of these attempts. He then proceeds to wait almost 20 years. There was also pretty clear record evidence that whatever the defendant's mental capacity was, he understood that if he wanted to challenge his sentence, all he had to do was say, I want to appeal.
Okay, so that's what the district court judge said. But what evidence is there that he had the capacity to do that no matter what his intellectual ability?
That is in the record, and it was from, I think it's record volume 9, the hearing in Smith 3, where ultimately the defendant, it was very clear, he understood that if he wanted to challenge his sentence, all he had to do was say, I want an appeal. And he never asked that.
And at that point, the psychologist or the evaluator said that he was basically had the intellectual ability of an 8-year-old by that time, right?
I don't frankly know. And again, I think that it's fair to look at this expert's result through the lens of what the scope of work he was asked to do was. And that scope of work never included documents in this case, reading any transcripts, and he was not able to definitively say what the defendant would or would not have been able to do or in this case at that time. I see that I'm out of time. I've touched on the merits of the discretionary sentence and the goalie. If I could have just one moment, if there are any questions on that, I would be happy to answer them. I think the record's pretty clear. This was a discretionary sentence. The defendant actually will be eligible for parole in right about 6 years from now.
I was going to ask that back in the indeterminate days, what was the actual sentence when he would become parole eligible, considering all the consecutive nature of this? Because it's so much different than it is now. Yeah, I was going to ask Mr. Nay that, but what was the effective sentence of when he would first become parole eligible?
35 years. 35 years in prison, and then he had a consecutive 30-day jail sentence.
Okay, that's okay. So when you combine all the consecutive nature of it, the mandatory minimum gets to 35 years.
Correct. I think that's 223717 as we cite in our brief.
Thank you. I meant to ask that.
Subsection C, yeah, because these were ordered consecutive, it would have been 15 years for each of the life sentences.
Right.
And you would get good time credit on the 10 years to life, so that was only 5 years, so 35 total. Seeing no further questions, I thank this court for its time. Again, I'd ask this court to simply apply its procedural rules and dismiss this appeal for lack of jurisdiction and put an end to this prolonged battle over something that the defendant never really wanted to do.
Thank you, Mr. Gallant. Renee, you reserve 3 minutes.
Thank you. Well, this court in State versus Flynn said the following, and it's in our brief. If the trial court receives a motion for modification within 120 days of the sentencing hearing, it has jurisdiction beyond the 120 days to decide the motion. In the event a motion to modify is filed, the triggering event is not the district court's ruling from the bench, but rather the filing of the journal entry. Now, we have G, we have Myers from the Court of Appeal, we have Flynn, but this 16-year-old intellectually disabled kid should figure out that the Supreme Court's, number one, figure out what they're saying, this court is saying, but figure out that it really doesn't mean what it's saying. We say the state had knowledge of this, could have filed the journal entry anytime. That's the trigger. And the trigger has not been pulled here yet, period. I would also note that when we look at Justice Standridge raised the issue of Dr. Stone did consider all of the issues here. He read the transcripts, he read the plea agreement, and he said that the language of the plea agreement was such that he would not have been able to understand it, that he had the auditory memory of a 6-year-old, even when he's told something. I know Dr. Stone said he'd hear it and then it becomes blah, blah, blah. He wouldn't have understood the provisions there. And in fact, the plea agreement itself is wrong because the plea agreement says the appeal must be filed within 130 days of sentencing. Well, it wasn't the law then. And as noted, it's 10 days after the issue is ruled on that the callback would be ruled on. Justice Standridge also asked, where's it in the record of what the defendant would have done? It's all over the record. Mr. Smith testified at 3 different hearings, I wanted to appeal. I wanted to appeal. There was no refutation of that. I mean, we can just make up things, I guess. Oh, he didn't really mean it. He's not believable. But his grandmother testified, which this court commented on in Smith 2 as having validity. We have a record that he was trying to get hold of his lawyer to appeal. You don't call your own lawyer to do a 1507 on him with respect to the state's argument what this could have been. And finally, on the issue of the sentencing, when he was sentenced, the court said, here's what we're going to do. Here's your sentence. You're going to prison. It does not mention his age, but it says, now when I get the call back, when I get the report, I'll consider all the things, including age. but that's not the sentence. The age must be considered under Montgomery, under Miller at the time of sentencing. A review was not another sentencing. Otherwise, my client would have had the right to be there, which he clearly wasn't. So we submit that if we want this long nightmare over, as the prosecutor argues, let's, for heaven's sakes, give this guy an appeal. This could have been over years ago. That's all we're asking for. Not to set him free, let him appeal. And we submit that the law, the procedural law, which this court has said is appropriate, in G, and subsequently allows him that right.
How do you deal with Parks? I mean, Parks is pretty plain that appellate jurisdiction is statutory, and we say that all the time anyway. And so, 2011, I think Parks is 2011, yeah. So there's at least a line drawn there that G is not good law.
But I think the difference in Parks, and I think the difference in Parks here is that we are going off of what the law was when Mr. Smith was sentenced and what his rights were when he was sentenced. Parks wasn't the law then. We can all agree to that. Hadn't been decided. I think I'm correct, right?
Well,
In 1993.
The point is that the statutes were the statutes. And just follow the language of the statutes, and you get to a conclusion that there was no appellate jurisdiction.
Well,
You need to use equitable exceptions to get court jurisdiction. And Parks says we don't do that. We can't do that.
well, the statutes are 134, the rule, and 6258.
Rule's not the stat-
Well, 6258.
Right.
This was never served, and that was agreed upon. No one knew this happened. I think again, excuse me if I'm misremembering Parks, but in Parks, at least people knew it had happened. The event had happened. Correct?
Well, you're using 6258, which is a civil procedure statute, opposed to the appellate jurisdiction in a criminal case under Chapter 22, right?
Well, it talks about the effect of a journal entry. And it reads, if you read G and the others, it talks about 134 and 258 as existing sort of in the same universe and commenting on each other. So again, we can misinform this 16-year-old. He doesn't understand. A journal entry is ordered by the court, which is never filed. Even the minute sheet is never served, but he's got to follow some kind of procedure, which up until Parks, I guess, would have left the door open for him. Your Honor, I guess we can say that somehow the procedure that existed at the time, that under G and under Flynn, that the triggering is the filing of the journal entry. What defendants were told no longer applies. When the court said in Flynn in 2002 that the trigger is the journal entry, we were just kidding them. That should be the trigger, and it has never been filed. Why should all the mistakes or errors or what do we want to call them here go to the detriment of the defendant and not the prosecutor who'd been ordered by the court to file a journal entry? And it still hasn't followed that order.
Counsel for the state mentioned that he thought that the first Ortiz exception had been raised and abandoned in the first appeal. Can you address that?
Certainly. When we tried to raise the first Ortiz issue, saying it was in when this court remanded the last hearing, the state then argued, oh, no, it wasn't raised. Right, we are asking the court, if you, in my quote from my brief, Judge, we're trying to just give liberal interpretation to the pro se finding. Well, the state then, which was convenient, argued it hadn't been raised in the pro se filing of the defendant. And the court said, well, whether it's raised or not raised, I'm not reaching it. So it was never abandoned. We were always going off that plea.
So there was never a ruling by an appellate court that it had been abandoned.
No, or by a district court. The district court just said, I'm not, whether it's there in the pro se pleadings or not, I'm not going to reach it because it wasn't part of the mandate. And this court upheld that ruling.
Questions? Thank you, Mr. Nay.
Thank you, Your Honor.
And thank you to both counsel for your arguments in this matter. The court will take it under advisement.